House Resolution Number 746, Resolution dismissing the complaints for impeachment filed by Attorney Andre R. De Jesus and by Liza Largoza Maza, Teodoro A. Casino, Renato Reyes Jr., Attorney Nery Colmenares et al. Against President Ferdinand Bongbong R. Marcos Jr.
Majority Leader.
Mr. Speaker, I move to recognize the chairperson of the Committee on Justice, Representative Attorney Jervil Jinky Beatrix Luistro.
The Honorable Representative Attorney Jervil Jinky Beatrix Luistro, Chairperson of the Committee on Justice, is hereby recognized.
Madam Speaker, distinguished colleagues, ladies and gentlemen, I rise today to sponsor the committee report and the accompanying resolution from the Committee on Justice, formally recommending the dismissal of the two impeachment complaints filed against President Ferdinand R. Marcos Jr. The first complaint, the De Jesus complaint, was filed by Attorney Andre R. De Jesus and endorsed by the Honorable Representative Journey Jet V. Nisay of the Pusong Pinoy Party List. The second, the Maza et al. Impeachment complaint, was filed by Liza Largoza Maza, Teodoro A. Casino, Renato Reyes Jr., Attorney Nery Colmenares, and 32 other complainants, endorsed by the Honorable Representative Antonio Tino of the ACT Teachers Party List, Honorable Representative Sara Ilago of the Gabriela Women's Party List, and Honorable Representative Rene Luis Co of the Kabataan Party List. The Supreme Court, through its latest resolution, affirms that impeachment is a powerful process to exact accountability from the government, especially from public officers mentioned in the Constitution. We affirm that accountability, when pursued in accordance with the Constitution, is a core value in a democratic and Republican government. Madam Speaker, although impeachment is political in nature, it is not without limits. As held in Francisco versus House of Representatives, it remains subject to strict constitutional standards, gravity, and due process. Accountability is not optional. It is the soul of our democracy. Malinaw po ang naging husga ng Committee on Justice. Ang mga reklamong ito, although both were found sufficient in form, are insufficient in substance. On sufficiency in form, as chairperson of the Committee on Justice, this representation has consistently emphasized that the determination of sufficiency in form is governed by rules. To pass this stage, 1, it must be verified by the complainants. 2, it must be based on personal knowledge or supported by authentic records. 3, it must be endorsed by a member of the House. And 4, it must include a resolution of endorsement. Section 3 of the Rules of Procedure in Impeachment Proceedings states that an impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. Kaugnay nito, ginamit nating gabay ang Section 22 ng 2019 Amendments to the 1989 Revised Rules on Evidence pagdating sa definition ng personal knowledge. Nakasaad dito, a witness can testify only to those facts which he or she knows of his or her personal knowledge. That is, which are derived from his or her own perception. Madam Speaker, distinguished colleagues, during the meetings, the Committee on Justice meticulously examined every technical detail to uphold the procedural and substantive integrity of this process. Upon thorough physical inspection and determination, the committee verified that the documents were indeed complete. Consequently, on February 2, 2026, both complaints were declared sufficient in form. On sufficiency in substance, following this, the meetings on February 3 and 4, 2026 were dedicated to a rigorous and exhaustive evaluation of their sufficiency in substance. As the Supreme Court ruled in Gutierrez versus House of Representatives Committee on Justice, the determination of sufficiency in form and substance of an impeachment complaint is an exponent of the express constitutional grant of rule-making powers of the House of Representatives, which committed such determinative function to the public respondent, in this case, the House Committee on Justice. Section 5, determination of sufficiency in substance of the House Rules on Impeachment. Should the committee find the complaint sufficient in form, it shall determine if the complaint is sufficient in substance. The requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. If the committee finds that the complaint is not sufficient in substance, it shall dismiss the complaint and submit its report as provided hereunder. Pursuant to the House Rules on Impeachment, the evaluation of a complaint necessarily involves the individual judgment and interpretation of House members, specifically the members of the Committee on Justice. Each member is empowered to assess the allegations based on their own appreciation of the facts, the grounds invoked, and the constitutional standards governing impeachment. Sufficiency in substance is not measured by the volume of bare allegations and annexes that are unsubstantiated by personal knowledge and authentic records. Madam Speaker, sa pagtukoy kung may sapat na substance, laging kinikilala ng Committee on Justice ang sound discretion ng bawat miyembro rooted in their individual appreciation of facts. In these two complaints, malinaw po ang naging desisyon ng Committee on Justice. The substance is insufficient. The De Jesus complaint. Ang complaint ni De Jesus ay itinuturing na walang matibay na factual foundation. Based on the determination of this committee, it fails to meet the substance requirements for a proceeding as grave as impeachment. The complainant respectfully prays that this institution impeach the respondent for graft and corruption, culpable violation of the Constitution, and betrayal of public trust based on the following grounds. On the first ground, respondent violated the Constitution and betrayed public trust by surrendering former President Duterte to the ICC. Under the rules, allegations must be based on personal knowledge or authentic records, not merely on hearsay. Mere disagreement with foreign policy is not an impeachable betrayal. Impeachment is one of our gravest constitutional mechanisms and cannot be triggered by policy disputes. There is no overt act attributable to the President with respect to the arrest and alleged kidnapping of the former President. There is likewise no factual basis with respect to the allegation that the President surrendered the former President to a foreign tribunal and disregarded domestic legal processes. The complaint fails to identify a specific act constituting an abuse of power, nor does it state with particularity what the President did, when it occurred, or through what instrument it was committed. As noted by the late Father Joaquin Bernas, a betrayal of public trust must be of such a nature as to strike at the very heart of the government. On the second ground, respondent is unfit to serve as president due to alleged drug addiction. As noted during the meetings, these allegations are merely hearsay. The complaint relies almost entirely on a statement of a family member, unsupported by any affidavit, sworn testimony, or verified record, rendering its probative value non-existent. Nowhere does the complainant claim personal knowledge of these accusations, nor did he exert any effort to verify the truth before the filing. Kahit ang ating mga kasamahan sa komite ay binigyang diin ang mga fatal flaws ng reklamong ito, walang naipakitang nexus na direktang ugnayan sa pagitan ng akusasyong ito at sa anumang abuse of presidential power. Public accusations do not constitute the factual nexus necessary to satisfy a cause of action. On the third ground, respondent committed betrayal of public trust when he failed to veto unprogrammed appropriations and other unconstitutional provisions in the General Appropriations Bill. Madam Speaker, esteemed colleagues, a failure to veto is not an impeachable offense. Mere refusal to veto certain parts of a bill does not equate to a betrayal of public trust. It is within the President's discretion whether to approve or veto a measure. Ang pag-aproba o pag-veto sa isang panukalang batas ay isang executive prerogative or discretion ng Pangulo. Hindi sapat na sabihing maling desisyon ito para tawaging betrayal of public trust. As is stated in the record of the Constitutional Commission, July 26, 1986, even plain errors of judgment is not tantamount to betrayal of public trust. On the fourth ground, respondent engaged in graft and corruption through kickbacks and ghost project. The respondent is accused of orchestrating the insertion of massive amounts into General Appropriations Act to create a pool of funds for kickbacks. However, ang mga akusasyong ito ay purely conclusory. Ang reliance sa mga unverified video exposés na ginawa ng walang benefit of an oath or reliability safeguards ay itinuturing lamang na hearsay. Fifth ground, respondent created the ICI to shield corrupt allies. Respondent created the Independent Commission for Infrastructure, or ICI, which the complaint characterized as a contrivance to shield corrupt allies. As the Committee on Justice noted, the mere establishment of the ICI is not an impeachable act. Walang naipakitang overt act na personal na maiugnay sa Pangulo. The President's creation of an ICI, allegedly to shield corrupt allies, does not amount to a culpable violation of the Constitution. In fact, by creating the ICI, the President faithfully followed his constitutional mandate. In Luis Baroque C. Biraugo versus the Philippine Truth Commission of 2010, the Supreme Court declared that the President has the power and duty to create fact-finding investigative bodies pursuant to Article 7, Section 17 of the Constitution. The creation of an investigative body like the ICI is an exercise of executive policy. Moreover, the integrity and competence of the members of the ICI belie the allegation that the ICI was created to shield the corrupt allies of the President. The investigations conducted by the ICI involve both allies and non-allies of the President. The complaint fails to allege ultimate facts showing abuse, unlawful purpose, or concrete acts of favoritism attributable to the President. Policy failure or perceived ineffectiveness of an office is not an impeachable offense. Allegations of selective enforcement of the laws require proof of intent, which complainant failed to demonstrate. Betrayal of public trust is not about policy differences or leadership style. Legally, it requires proof of gross faithlessness, a tyrannical abuse of power, or a total neglect of official duty. Impeachment must be grounded in clearly pleaded facts, not in suspicion or political considerations. Public suspicion is not proof. Moving forward, the Masa et al. Complaint, idineklara ring insufficient in substance. First act of alleged betrayal, the BBM parametric formula. This charge focuses on the so-called BBM parametric formula. The complaint argues that this formula is a gross exercise of discretionary power that constitutes a betrayal of public trust. While these allegations may sound grave, let's be clear, an imperfect policy direction is not an impeachable offense. Failures within these programs cannot be automatically imputed to the President. Impeachment is not a residual ground to punish policy choices. Pursuant to our rules, sufficiency in substance requires a recital of facts, alleging that a methodology is called the BBM parametric formula is merely a descriptive label. It is not a factual recital that the President authored, directed, or controlled it with corrupt intent. Second act of alleged betrayal. The complaint alleges an abuse of discretionary power over the release of unprogrammed appropriations to finance a systemic corruption scheme circumventing congressional oversight. Unprogrammed appropriations are not prohibited. They are expressly recognized under Section 35, Chapter 5, Book 6 of the Administrative Code of 1987. Presidential approval of their release is a statutory mandate, not a discretionary indulgence. Even if the Supreme Court found Special Provision 1D of the 2024 GAA authorizing the transfer of excess or fund balances of government-owned or controlled corporations to fund unprogrammed appropriations in the case of Pimentel versus Office of the President. This ruling does not establish that an impeachable offense on the part of the President. Third act of alleged betrayal, budgetary insertions and kickback schemes. This is the most serious, yet least unsubstantiated charge. The allegation that the President directly ordered the insertion into the 2025 GAA to receive kickbacks. The complaint relies on testimonial assertions unsupported by documentary corroboration. The claims and records are unauthenticated, undated, and of unknown provenance. The complainant's implicity rely on a theory of command responsibility, but Philippine jurisprudence is clear. In Rubrico versus Arroyo, the Supreme Court rejected the automatic attribution of liability to the President, absent proof that the President knew of or sanctioned the alleged wrongdoing. Institutional shortcomings do not equate automatically to constitutional betrayal. As some members pointed out, the alter ego doctrine cannot be used to establish the personal culpability required for impeachment. Furthermore, they added that the President never issued an executive order to institutionalize this formula. Madam Speaker, distinguished colleagues, base sa desisyon ng komite, parehong insufficient in substance ang De Jesus at Masa et al. Complaints. To satisfy the requirement of substance, a complaint must allege ultimate facts. Based on the definition of ultimate facts, as established in Section 3, Rule 3 of the Rules of Court, by jurisprudence, ultimate facts are the essential facts constituting the cause of action. As the Supreme Court reiterated in the recent case of heirs of Teodoro Tulawan versus Mateo, general allegations that a contract is valid or legal or is just, fair, and reasonable are mere conclusions of law. Likewise, allegations that a contract is void, voidable, invalid, illegal, ultra vires, or against public policy without stating facts showing its invalidity are mere conclusions of law. If the complaint does not provide an explanation or narration of facts stating with particularity the circumstances constituting fraud, the bare allegation of fraud would be deemed an unfounded conclusion of law. Ultimately, these complaints fail to establish a factual nexus between the President and any impeachable offense. They attempt to reframe mere policy disagreements and routine executive functions as a betrayal of public trust without any showing of bad faith or malice. Dahil dito, on the De Jesus complaint, upon a motion to declare insufficient in substance, the committee voted with 42 affirmative votes, 1 negative vote, and 3 abstentions. De Jesus complaint was declared insufficient in substance. On Masa et al. Complaint, upon a motion to declare it sufficient in substance, the motion was defeated with only 7 affirmative votes and 39 negative votes. It was likewise declared insufficient in substance. Mr. Speaker, Madam Speaker, distinguished colleagues, complaints that are fundamentally insufficient in substance must be dismissed, not indulged, for the sake of political theater. In this hall, the interest of the Filipino people must always come first. To do otherwise is to degrade impeachment from a constitutional safeguard into a weapon of harassment. While our rules state that substance is met by a recital of facts and jurisdictional requirements, wag nating kalimutan, impeachment is a sui generis proceeding. It is a class of its own. Our decision reflects the committee's faithful adherence to the strict standards of the 1987 Constitution. It is a definitive declaration that in this hall, the rule of law prevails over the rule of rhetoric. Kaya naman, on behalf of the Committee on Justice, this representation respectfully move for the approval of Committee Report number 111 and the adoption of House Resolution number 746, dismissing the 2 impeachment complaints against President Ferdinand R. Marcos Jr. I urge my colleagues to defend the integrity of this institution and the sanctity of the impeachment process. The 1987 Constitution has lodged this extraordinary power in us, the duly elected representatives of the Filipino people. Tungkulin nating timbangin kung ang mga akusasyong ito ay may katotohanan o sadyang mapanira lamang. Tayo ang boses ng bawat Pilipino dito sa plenaryo. I urge every member of this House, do not consider this duty as a matter of convenience. Decide with your conscience. Isipin natin ang kapakanan ng bawat Pilipino. Let us prove that in this hall, the interest of the people always comes first, and the rule of law remains supreme. Thank you, Madam Speaker.
Majority Leader.
Madam Speaker, I